it's a summary of termination of a civil marriage. A civil marriage can be terminated or can dissolved in 3 ways. The first is through death of a spouse or both spouses. When the spouses are married in community of property, the death terminates the marriage as well as the joint estate. The executor that has been appointed to administer the deceased estate is going to wind up or administer the deceased estate, and during the winding up process, the deceased estate debts that were incurred or that were made before the marriage are paid from the 50% share of the debtor. In other words, of the spouse who made the debt, irrespective of whether the debtor or their spouse has passed away or is the surviving spouse. When the spouses are married out of community of property, the antinatural debt, in other words, the antinatural debts are not terminated by death of either spouse. So, as I said, when spouses are married in community of property, the marriage terminates the marriage and the joint estate. And when the spouses are married out of community of property, the death terminates the marriage, but the antinatural debts, the debts that the spouses have, are not terminated by death of either spouse. The executor who winds up or who administers the deceased estate has a responsibility of ensuring that the debts are paid, the debts of the spouse who have passed away are paid from their estate. Before, this applies for both if they're married in community of property or out of community of property. The debt needs to be paid first before inheritance can be distributed. In other words, when the spouses are married in community of property, before the 50% share of their surviving spouse can be given to them, and also the rest of their inheritance, and also when the spouses are married out of community of property with the accrual system, they need to make sure that the debts are paid first. Debts are paid first before inheritance can be distributed. When spouses when the spouse passes away, and let's say the surviving spouse was financially dependent on their spouse, they have a right to claim maintenance in the deceased estate. This maintenance is claimed in terms of the Maintenance of Surviving Spouses Act. The claim can be brought by a spouse who is unable to provide for themselves, irrespective of the marriage contract or the matrimonial property system that their spouses have entered into. So this means that whether the spouses are married in community of property or out of community of property, a spouse who is in financial need has the right to bring in a claim on the deceased estate in terms of the Maintenance of Surviving Spouses Act. The surviving spouse must claim a reasonable amount that they will need to survive. When determining the reasonable needs of a surviving spouse, there are factors that are taken into account. Please see page 117 of your prescribed textbook to read and to formalize yourself with these factors that are taken into account when determining the reasonable needs of the surviving spouse. This was the first if a marriage is dissolved through death. The second way a marriage can be dissolved is through an annulment of a voidable marriage. An annulment is a legal procedure. that is taken, or a legal position. In other words, the spouse brings in a matter to court to have the marriage declared null and void. We must remember that a voidable marriage is a marriage that has not complied with all the legal requirements of entering into a legally recognized marriage, but that marriage is not void. In other words, it's not automatically null and void. So a spouse who wants their marriage, which is voidable, to be declared null and void, has to bring in a court application to have that marriage declared null and void. The third way of terminating a civil marriage is through the divorce process. A marriage through a divorce process can only be dissolved by a court of law, and can only be dissolved either by the High Court or the regional court through their divorce, the divorce section. All regional courts have a divorce courts section which specializes in dissolving marriages, be it civil marriages or other marriages, customary marriages, and civil union marriages. A divorce is regulated by the Divorce Act, and in terms of the Divorce Act, there are 3 grounds to dissolve a marriage. The first ground is the irretrievable breakdown of the marriage. The second ground is the incurable mental illness of a party or of a spouse in the marriage. And the third ground is the continuous unconsciousness of a spouse to the marriage. The grounds for divorce can be found in Section 4, subsection 1, and Section 4, subsection 2 of the Divorce Act. Please see page 121 to 122 of your prescribed textbook for the guidelines on all the grounds for terminating a civil marriage. Section 5, subsection 1, and Section 5, subsection 2 of the Divorce Act regulates termination in terms of mental illness or for unconsciousness. So Section 1, Section 4, subsection 1, and Section 4, subsection 2 regulates the grounds for an irretrievable breakdown of a marriage. And Section 5, subsection 1, and Section 5, subsection 2 regulates the ground for an incurable mental illness or continuous unconsciousness of a spouse to the marriage. It is also very important to know that once a spouse has filed for a divorce court does not have the discretion to refuse to grant a divorce once it has been proven that the marriage has irretrievably broken down. The exception, however, is Section 5, subsection A of the Divorce Act, which regulates marriages which have been entered into in terms of civil marriage. In other words, in terms of the Marriage Act, as well as those that have, as well as religious rights, religious grounds. For example, if spouses enter into a religious marriage and over and above, they enter into the marriage in terms of the Marriage Act. So those spouses entered into a marriage using 2 systems, their religious rights, religious marriage, as well as the civil marriage. Section 5 Section 5, capital A, provides that if it appears to a court that granting a degree of divorce will result in either spouse or both spouses being unable to remarry because of their religion, unless the marriage is also dissolved in accordance with the prescript of that religion. The court can refuse to grant a degree of divorce unless it is satisfied that the steps will be taken to dissolve the religious marriage or to remove the bar or to remove the obstacle that will prevent the spouses from remarrying. So the only exception is Section 5, capital A. That is the only exception when a court can refuse to grant a divorce. Other than this, no divorce court or no presiding officer in a divorce court has a right to refuse to grant a divorce, a degree of divorce, if it has been proven that the marriage has irretrievably broken down. Now let's move on to the patrimonial consequences of a divorce. When spouses are undergoing a divorce, one of the processes that occur is to determine how are they going to dissolve the matrimonial estate. And dissolution of the matrimonial estate depends on the kind of marriage contract that they have entered into. Spouses who are married in community of property, they jointly co-own all the assets and the debts of the joint estate. If spouses are married out of community of property without the accrual system, each spouse, they can agree that each spouse can retain whatever is theirs. And if spouses are married out of community of property with the accrual system, the accrual calculation or the accrual calculation process can take place so that the spouse whose estate is lower gets to keep everything that is theirs, and that spouse will have a share in the other spouse's estate, and a share which is half the difference between both their estate values, net values. Spouses, however, are allowed to determine themselves how they want to dissolve their matrimonial estate, irrespective of the kind of marriage contract that they have entered into. In terms of Section 7, subsection 1 of the Divorce Act, spouses can enter into a written agreement. This agreement is called a settlement agreement. A settlement agreement, it is a written document that sets out the terms of the spouse's divorce. For example, the division of their matrimonial estate, the parental responsibilities and rights of the minor children, and also of the adult children, if those adult children are still dependent on their parents. Or on the divorcing spouses, maintenance of both the minor and dependent adult children, and also of the spouses who are still in financial need, and pension interest and ancillary relief. Pension interest. It is a pension interest, which is pension funds, retirement annuities, and provident fund. They are deemed to form part of a spouse's asset during a divorce for the purpose of determining the matrimonial benefits. So, for example, if spouses are married in community of property, the Supreme Court of Appeal in the case of Ndaba versus Ndaba have confirmed that the spouses or the spouse who does not have a pension automatically has 50% share of their spouse's pension. In other words, the member spouse's pension. Spouses each have a 50% share over each other's pension benefits. Please see page 131 to page 132 of your prescribed textbook for a calculation of pension interest. You also need to know the difference between pension interest and pension benefit. Pension interest is an interest that has not yet accrued to the member by the time of divorce. It excludes a withdrawal benefit that accrues to a spouse prior to a divorce. Pension benefit, it is a withdrawal benefit, or it is a withdrawal or a pension. Okay, let me say pension benefit, it is a withdrawal benefit that has already accrued to the man. Basically, it is a pension that has already been withdrawn and the money has already been paid over to the spouse. So that is known as pension benefit. But pension interest is the one that is still in the hands of the pension administrators. Section 7, subsection 8, subsection A of the Divorce Act empowers a court granting a decree of divorce to order the members' fund, in other words, the pension administrators, to make payment to the non-member spouse. So in other words, if let's say a husband works for the government department and has a pension benefit, the government employees pension benefit, during a divorce, the divorce court or the high court has the powers to order that the pension administrators, government employees pension fund gives the non-member spouse 50% share of their members' pension fund, or as we call it, the pension interest. So Section 7, subsection 8 of the Divorce Act empowers a court granting a decree of divorce to order the members' fund to pay any part of the pension interest. Most of the time is 50% when spouses are married in common property, which is due to their member spouse directly to the non-member. Please know that the non-member has a choice of saying, I want the money to be paid directly into my bank account, or the money to be transferred to another pension fund. Please see page 133 to page 134 of the prescribed textbook for a discussion on the payment or transfer of the non-member spouse's portion of the pension interest. Although we have a forced divorce system, and when spouses are married, the general rule, if I may say that, is that the marriage must be dissolved, or the matrimonial estate must be dissolved in accordance with the marriage contract or the matrimonial property system that the parties have entered into. There is what is known as forfeiture of patrimonial or matrimonial benefit. Section 9, subsection A of the Divorce Act empowers the court that grants a divorce order to give an order of either total or partial benefit of the matrimonial benefit. Before the court can give this order, there are factors that the court needs to consider. Firstly, the duration of the marriage. Secondly, the circumstances that led to the breakdown of the marriage. And thirdly, any substantial misconduct on the part of either spouse. It is important to know that besides the duration of marriage and the circumstances which led to the breakdown of the marriage, the misconduct, it is taken into account when the court determines forfeiture. But the court does not just consider misconduct. It must consider substantial misconduct. That is a misconduct that is so gross that it will really be so unfair that their spouse will get the share of their matrimonial from the matrimonial estate. For example, if the parties are married in common of property, and upon getting married, the one spouse was never available in the marriage, there is excessive extramarital affairs, the spouse never contributed financially or non-financially in the estate, and the spouse who is requesting forfeiture was literally the one holding the family, and although they were married, the situation was just that they were not in a marriage at all. So it must be a substantial misconduct, and a spouse must be able to prove that if the forfeiture is not granted, it will really be unfair. Also, you need to know that a spouse does not forfeit what is theirs. So if the spouse is the one, let's say the spouse entered the marriage with an immovable property, or after getting married, he or she bought the immovable property and paid it off and everything. But besides that, they never contributed anything, and they behaved in such a grossly misconduct manner. When the court orders that they forfeit either 50% of the matrimonial estate or partial, the court cannot order that they forfeit what is theirs, something that they spend money on, and something that they spend money on, and something that belongs to them. So the court can order that they forfeit 50%, let's say, of everything in the joint estate except this immovable property, whereby they will retain their 50% and the other spouse will also get 50% of that immovable property. So forfeiture may only be granted if the court is satisfied that a spouse will be unduly benefited if the order is not granted. Okay. Let's move along. Now, redistribution of asset. Redistribution of asset is also another way that the court deviates or it doesn't follow the matrimonial property system of the spouses. Redistribution of assets is regulated by Section 7, subsection 3 of the Divorce Act. Section 7, subsection 3 empowers the court to redistribute assets of the one spouse to the other if it deems to be just and fair. There are prerequisites, in other words, there are requirements that must be complied with before distribution can actually be ordered. Section 7, subsection 3 has two clauses which are applicable to non-Black spouses and to whites, colored, and Asians. Section 7, subsection 3, subsection A of the Matrimonial Act applies to whites, Asians, and coloreds. It applies to spouses who are married before 1 November 1984. That is before the Matrimonial Property Act came into existence. And the party's marriage or the spouse's marriage must be out of community of property in terms of the antenatal contract. Before the Matrimonial Property Act became law, non-Black spouses, the Asians ones, the colored, had a choice of either getting married in community of property or out of community of property without the accrual system. The accrual system did not exist at the time. So when they wanted to marry out of community of property, they needed to enter into an antenuptial contract excluding community of property. When the Matrimonial Property Act came into existence on 1 November 1984, it introduced the accrual system. But when it came into existence, the Matrimonial Property Act, was not retroactive. So in order to protect spouses who were married or who are married and are still alive out of community of property without the out of community of property, and the marriage was entered into before 1 November 1984, and they are non-Black spouses. A spouse who had contributed to their spouse's estate, could ask the court to redistribute assets from their spouse's estate to their estate. Normally, it would have been wives who most of the time were housewives. They will ask the court to redistribute assets from their husband's estate to their estate. It is important to note that on 11 May 2002, there was a landmark judgment in G versus Minister of Home Affairs, G, which is for Greyland, the applicant or the wife who brought in the case was Mrs. Greyland. And the matter was brought in at the Pretoria High Court. The Pretoria High Court held that Section 7, subsection A of the Matrimonial Property Act, it is unconstitutional and invalid in that it does not extend to spouses who are married out of community of property without the accrual system, but those marriages occurred after 1 November 1984. This judgment is pending confirmation by the Constitutional Court. Now, for Black spouses, the provision applicable for Black spouses is, or let me say was, Section or is Section 7, subsection 3, subsection B. This section previously stated or is stated that Black spouses who were married, whose marriage was automatically out of community of property, without which was entered into without the antenatal contract. This was the default matrimonial property system for Black people who entered into a civil marriage before 2 December 1988 in terms of Section 22, subsection C of the Black Administrative Act. This section 22, subsection 6 of the Black Administrative Act has been declared unconstitutional by the Constitutional Court in the case of Sithole versus Sithole. The result of this, they declared it unconstitutional, and after they declared that all civil marriages that that were automatically out of community of property before 2 December 1988 are now deemed to be automatically in community of property. The effect or the result of this is that the provisions of Section 7, subsection 3, subsection B are no longer applicable to Black spouses because the provision itself had said that the marriage had to be entered into in terms of Section 22, subsection 3 of the Black Administrative Act. But now this section has been declared unconstitutional, and because the marriages had to be out of community of property, but for now, these marriages are now automatically in community of property. The unfortunate situation that we find ourselves now is that for Black spouses who entered or who are in a civil marriage which was entered into after 2 December 1988, let's say from 3 December 1988, and they are married out of community of property in terms of the antenuptial contract, there is no provision or there is yet a court judgment that gives them the right to also ask the court for redistribution of assets from their spouse to their estate. As I stated that for non-white spouses, the G versus Minister of Home Affairs has declared Section 7, subsection 3, subsection A unconstitutional because it does not take into account marriages that occurred after 1 November 1984. But there is yet a court judgment that invalidates and renders Section 7, subsection 3, subsection B unconstitutional. Please read your textbook to also understand the constitutional dilemma of Section 7, subsection 3. For example, it does not apply to spouses in same-sex marriages. It does not apply to spouses whose marriages or where the spouses are non-South African, not the spouses, the husband is a non-South African, and where and from the spouse's country, they do not have a provision like Section 7, subsection 3. Just to quickly do a recap, remember that South African women, they follow the laws of the husband's country. So if a South African woman gets married to a South African man, the laws of South Africa will apply. But if a South African woman gets married to a Nigerian man who is only in South Africa, let's say that Nigerian man is not a citizen of South Africa, but they get married in South Africa, the matrimonial property system of Nigeria will apply, and the automatic divorce system is out of community of property unless the spouses enter into an antenuptial contract which renders their marriage in community of property. So if a spouse is married to a foreign husband, a wife is married to a foreign husband, and the foreign husband's country does not have any provision regarding redistribution of assets, those spouses, unfortunately, they do not, or at the present moment, they cannot request the court to redistribute assets from one spouse to another. Also, it is important to note that the Constitutional Court, in the case of Gumede versus the President of the Republic of South Africa, they have held that, or they have extended the court's judicial discretion, in other words, only the court dissolving a marriage has the discretion or has the power to decide whether to order redistribution or not. So in the Kumete case, they have extended this or they extended the right to claim using Section 7, subsection 3 to spouses who are in a customary marriage, irrespective of when the marriage was entered into and irrespective of the matrimonial property system of the marriage. The requirement of a redistribution order. Please, it is important to know that Section 7, subsection 3 can only be ordered, or the powers have the powers to only order it if there are certain conditions that have been complied with. So when you study this section, you need to study Section 7, subsection 3 in line also with Section 7, subsection 4, subsection 5, and subsection 6. So those conditions also the court must take them into account. For example, Section 7, subsection 4 of the Divorce Act states that the spouse who seeks redistribution must have contributed directly or indirectly to the maintenance or increment of the spouse's estate during the subsistence of the marriage. And the court must be satisfied that by reason of such contribution, it is equitable and just to make a redistribution order. Please also know that the position of foreign marriages and Section 7, subsection 3, especially Section 7, subsection 9, which says of the Divorce Act, it empowers the South African court, which grants a divorce, to order redistribution of assets only if the foreign state or the foreign country also has the powers to redistribute assets. So in other words, in the country of the husband, the foreign husband, if they have provisions which also allows the court to redistribute assets, it's only then that our court in South Africa can make this order. If the foreign country does not have those provisions, the South African courts also are powerless, or there is no provision to actually make such an order. This is in terms of Section 7, subsection 9 of the Divorce Act. Now, maintenance of a spouse after divorce. When spouses get married, there is a automatical duty for the spouses to maintain each other. And this duty comes to an end when the marriage is terminated. There are, however, two exceptions. The first one is Section 7, subsection 1 of the Divorce Act. This is when the spouses, in their settlement agreement, they agree that one spouse will pay spousal maintenance to the other. And this settlement agreement needs to be made an order of court. The second exception is Section 7, subsection 2 of the Divorce Act. This section states that the court has a discretion to make an order for payment of post-divorce spousal maintenance for any period or up until death or remarriage, if there are certain conditions or factors that can be proven. Please see section 1, please see page 158 to 159 of the prescribed textbook for the factors that the court must take into account when determining whether to grant an order for post-divorce spousal maintenance in terms of Section 7, subsection 2 of the Divorce Act. You also need to know the types of maintenance that we have. We've got rehabilitative maintenance, which is maintenance for a limited fixed period of time. We have lump sum maintenance, which is maintenance that is paid as a lump sum. And we have a token or nominal maintenance. This is when there is no reasonable ground to grant maintenance at the time of divorce, but it can be foreseeable that in the future a spouse might be in need for maintenance. For example, let's say a spouse is working, but that spouse is in a fixed contract, and there is a possibility that that contract will not be renewed. So at the time of termination of the marriage, the spouse might not be in need of maintenance because they are getting in an income. But once the marriage is, their contract is, or when the contract ends, they may find themselves unemployed and thereby in need of maintenance. And the other type of maintenance is the most common one, the monthly payment of maintenance. The monthly payment of maintenance. Okay. Now, rescission, suspension, and variation of a maintenance order. This is regulated by Section 8, subsection 1 of the Divorce Act. This section states that a maintenance order granted in terms of the Divorce Act may be rescinded, suspended, or varied if there are sufficient or good reasons for doing so. Termination of a maintenance order. A maintenance order granted in terms of Section 7, subsection 1 of the Divorce Act, that is through a settlement agreement, is terminated in terms of the terms. In other words, in accordance with the terms in the settlement agreement. But the one that is granted in terms of Section 7, subsection 2 of the Divorce Act, that is a maintenance that is being granted through a court order. The duty to pay maintenance comes to an end as per court order. This can either be through death, remarriage, or if the rehabilitative maintenance period has now come to an end. Students, this brings to an end the summary for termination of a civil marriage. Please remember that you are still required to study your prescribed textbook, you study your the study guide, and also the updated information that we post on the tutorial letters. Thank you for taking time to listen. Please feel free to send me an email should you need to talk to me one-on-one or should you need clarification on something. My email address is monarkn@unisa.ac.za. Thank you, students, and good luck with your studies. Thank you. Goodbye.